All right, buckle up because this courtroom session starts with a defendant facing multiple serious charges. We're talking murder allegations, manslaughter counts, and even a drug possession charge. But what makes this case especially interesting? The legal strategy watched closely as the prosecution and judge debate which charge should actually go to trial. First, a move that could dramatically shape the outcome of everything that follows.
Good morning, you're Dalton Batiste. Answer out loud.
Yes.
And this is cause number 24 DCCR 0917 0918, 25 DCCR 1436, 1437, and then 24 DCCR 0407. Mr. Batiste is charged in the first two cases with murder, the second two with manslaughter, and the last with possession of marijuana. And what is the announcement?
Judge, we're still ready for trial. So
The state's ready for trial as well, Judge. We would prefer to proceed on the felony possession of a marijuana case first. I understand that if there's
Wait a second, did you catch that? The defense just mentioned the previous trial ended in a hung jury. That means the jurors couldn't unanimously agree on a verdict in criminal law. That's huge. It doesn't mean the defendant is innocent. It simply means the prosecution failed to convince every juror beyond a reasonable doubt. And now the state has changed tactics by re-indicting the case as manslaughter. The big question is, will the new charge make it easier for prosecutors to secure a conviction this time?
pushback from the court on that, given the fact that it's a state jail.
I'm not doing that.
No.
There's no way I'm gonna try a state jail felony on top of the other cases, so. So what are we actually, this is just an announcement. Did we get off the trial docket?
yes, Judge,
Remind me, please.
Yes, we tried this case. We had a hung jury.
Yes.
And the state elected to re-indict as a manslaughter, using the same theory, essentially as before. But the challenge is, of course, I think you said it on a review or whatever this is, because that's essentially a totally different charge than the fentanyl murder statute that we were arguing about last time.
And I'm fine, obviously, I would, if the state's going, I guess I'm a little confused. Two murder charges are still pending, and typically when something.
I filed dismissal on those.
Perfect, okay. So actually, we're just looking at the two manslaughters and the possession of a marijuana
That's
case. So I would, let's get it set then for a trial on the two manslaughter cases. And then let's see where we get from there.
Judge states on.
Now the tone in the courtroom shifts dramatically. The judge is about to address behavior from the defendant while he's been in jail awaiting trial. And this isn't just a lecture, right? It has real legal consequences. Inmates' behavior while incarcerated can absolutely come back to haunt them in court, especially during sentencing.
Also filed a motion.
Yeah, let's talk about that. So, Mr. Batiste, Mr. Coleman has filed a motion asking that I order you to act in a certain way out at our jail and to follow the rules and all of those things, which you should be doing anyway. I feel like we've probably already had this conversation, but what I can do, and here's what I don't necessarily want. I don't disagree with Mr. Coleman a single bit. You can ask Mr. Gertz, you can ask anybody that's been in front of me about how I feel about what is going on at our jail and how disrespectful inmates are being to the staff out there. And I'm doing whatever I can to try to get through to you all, because it can make things much worse. Much worse. Number one, if you go to trial on the manslaughter and you're found guilty, the jury's going to hear about all of it. They're going to march these correctional officers in here and they're going to say what you've been saying to them, that I'm not going to say today because a lot of people are watching. But you know what you're saying. You know how you're acting. I can promise you, Mr. Gertz is embarrassed for you because you don't help him help you by acting this way. Does that make sense? You're not one of these kids out there. How old are you? 26. So typically I'm dealing with 17, 18, 19-year-olds that are out there acting crazy. You're too old for that. What I don't want to do, Mr. Coleman, though, is cause the jail more grief by holding him in contempt and making him stay there even longer.
And-
Here's what we're going to do. We're getting the case set for trial on the manslaughters. We're going to get those tried. I'm not sure what I will do if you violate this exactly. I can't tell you right now, but I am ordering you to refrain from calling names. And if you need me to tell you everything, I can. If I need to be specific, I'll be specific. Because what I don't want you to come in here and say, well, I didn't say bitch, I said whatever. You know what I'm saying?
Yes, ma'am.
Behave. Don't call names. Don't tell them they don't have rank. Don't tell them I get what I want, B. That's not how you talk to somebody who's just going to do their job. They're just trying to go do their job and go home. And they got to deal with you and all the other people out there that are acting like idiots. So I'm going to order you to not do that. What that means is if you violate that order.
Let's break down what just happened there, because it's easy to miss the legal weight of it. The judge just issued a direct court order about the defendant's conduct in jail. If he violates it, she can hold him in contempt of court, and here's the kicker. She can stack penalties that means 6 months for each violation, in other words. Something as simple as repeated disrespect toward correctional staff could literally add years of additional time before his case even finishes.
And do it. And I get more incident reports. Mr. Coleman will ask me to hold you in contempt. And what I can do for every single incident, for every name you call, for every time you get written up, for every time you don't follow the rules, I can hold you in contempt.
And just like that, we move to an entirely different defendant and an entirely different legal issue. This next case isn't about jail behavior. It's about something even more fundamental in criminal law. Competency to stand trial before anyone can face a jury. The court has to determine that the defendant actually understands what's happening and can assist in their defense.
And I can order 6 months. And then I can stack 6 months for every name. Every time you say it, I can stack it, stack it, stack it. Do you understand?
Yes,
So you are now court ordered to follow the rules, which I shouldn't have to do, but I am. Okay.
yes, ma'am.
So I will set these cases for trial at the very next trial setting that we can get them on, and we'll go forward at that time. All right.
Thank you, Judge.
You can go back with the bailiff. All right. You are Heyman Brandon Jr.
Yes, ma'am.
This is cause number 21-36605. Mr. Brandon is charged with the first-degree felony offensive murder. Looking back at the file, which I'll take judicial notice of, it looks like Mr. Brandon was previously found not competent to stand trial and then sent to the appropriate facility. That looks like the Terrell State Hospital. And let's see. So are we now? I have received a report dated January 20th of 2026 from that facility with the finding that Mr. Brandon is now currently competent to stand trial. That evaluation includes a evaluation report, trial competency evaluation report that was prepared by a Dr. Jessani. The finding in that is, again, that Mr. Brandon is competent to stand trial. And that he is able to move forward with his criminal proceedings at the present time. That was also signed off on by a Dr. Lampley as well. So I have both of those doctors saying that he was currently competent to stand trial. We got him back and we're here now. So what is the announcement?
Your Honor, what I did was I kind of challenged that. I thought I was going to challenge that. So I sent Dr. Capon out because we were having a hard time communicating even when he got back to the jail 3 weeks ago or so. Dr. Capon went out, also corroborating the fact that he feels like he's also competent.
Okay.
So I reached out to Mr. Smith, who is still dealing with the family. I'm still dealing with him, which is going to take a little time. I have a insanity evaluation that's also being done by Dr. Gopon. If we could have a somewhat of an extended announcement, then we could come back and be prepared. Literally asking possibly, Governor Smith, for possibly a bench trial. The things
So
that,
let's do this. What I'll do then, based on that report, as well as the, your statement that Dr. Rapon is also going to, and I believe I do have a copy of Dr. Rapon's report. It was probably meant to be sent to you, but it was sent to the court.
I asked them to send you a courtesy
Okay.
copy so we could kind of see where I was
Any
thinking.
objection to me taking that into consideration with regard?
So here's the bottom line of what we just saw. Multiple psychiatric evaluations, including reports from 2 doctors, concluded that the defendant is competent to stand trial. That's a critical legal threshold if someone is found incompetent. The case pauses while they receive treatment, but now that the judge has ruled he's competent, the criminal process can move forward again. The court scheduled a 45-day reset, which gives both sides time to prepare and potentially explore defenses like insanity.
To competency as well.
There you go.
So I'm also going to take judicial notice then of the competency evaluation report prepared by Dr. Rapon. It's dated February 12th of 2026. Again, it has the finding that Mr. Brandon is competent to stand trial. Based on both of the reports from Vernon's as well as Dr. Rapon, I'm going to at this time find that Mr. Brandon is competent to stand trial. And what I'll do is I'll do about a 45-day reset to see where we get at that time. And then we will see if we can get an announcement at that point.
Yes, sir.
All right, you can go back with the bailiff, sir.